All right, let's now dive right into it. We are looking at the legal reasoning section of the CLAT paper. And basically, what we're going to do now is we're going to briefly cover the various legal topics that are they usually ask questions from in the CLAT paper. And we'll go through some sample questions just to give you a taste, an idea of what kind of questions you can expect. We will later on go much more detail into each of these topics. Okay. So starting off, first and foremost, what is law? Now, law, as we've discussed before, governs almost every aspect of our lives. Law determines our rights and duties, our freedoms and responsibilities. Laws can govern whether you can dress a certain way, whether you can eat a certain way, whether you can interact with others in a certain way, what is the extent to which you can say anything you want. Whatever it is, there is a law that governs that. Okay? So, coming to the theory of law, the English legal philosopher John Austin's command theory states that law is command of the sovereign backed by sanctions. Now, what this means is basically, first and foremost, there is a sovereign, that is, there is an entity which is in the habit of giving laws, and people are in the habit of following the laws that are given by this entity. Okay, the law is in the nature of a command, it is not in the nature of a suggestion. It is not in the nature of anything else but a command. Okay, so it's a command by the sovereign and it's backed up by sanctions. Sanctions basically refers to punishments. Okay, so law is command of the sovereign backed up by sanctions. This succinctly is one of the earliest definitions of law, but it's still seen as one of the best definitions of law till date. Now we'll turn our attention to constitutional law, which is one of the major sections from which questions are asked in the CLAT paper. First and foremost, what is the Constitution? The Constitution is the basic framework of laws of a country. Okay, in a country such as India, there are different frameworks in different countries. Some countries have a written constitution, some countries have an unwritten constitution, some countries don't have a constitution at all. But in the case of India, where we have a written constitution, basically it becomes much more easier to pinpoint exactly what the provisions of the constitution are, what their limits are, what rights the constitution gives to the people, what duties the constitution imposes on the people and on the state. So basically we have a written constitution. Why is so much importance given to the constitution? Now the constitution is as we've discussed, the basic framework of laws upon which other laws are created. So the constitution is, you can call it the basic law of the country, that no other law that can be made by the parliament can contravene the constitution. Thus, any discussion regarding the constitution always involves long, arduous debates, because if you're changing something that's very basic to the framework of the country, then it's natural that the topic gets debated a lot. If there is any change to be introduced, whether the time has come for certain provisions to be changed, to be amended, etc. Does every country have a constitution? No, every country does not have a constitution. In fact, every country, as we've discussed, does not even have a written constitution. For instance, the UK does not have a written constitution. It has an unwritten constitution, but through usage, through what is called convention, their constitution has been agreed upon what their constitution is, but they don't have a written constitution. Do all countries treat their constitutions with a similar degree of respect and sanctity? Yes, because the constitution is the basic framework of laws upon which all other laws are based. Okay, the Indian Constitution. Now coming to the Indian Constitution, the Indian Constitution is the longest written constitution in the world. It comprises of the preamble, which is kind of like the foreword to the Constitution. It defines the character of the Constitution. The Indian Constitution has 25 parts containing 448 articles. It has 12 schedules, 5 appendices, and 100 amendments have been made so far to the Constitution, and even more are being made every year. Now, in the Constitution of India, India is defined as a sovereign, socialist, secular, democratic republic. Sovereign, meaning that India determines its own destiny. Nobody else determines India's destiny. Socialist, why? Because India tends to have a welfare-based state. It looks out for the poorer people rather than just supporting, enabling the richer people to get richer. Although we don't have the best social security measures in place, still India is a socialist state. India is secular in the sense that everybody is allowed to practice and preach a religion of their choice, and there is no state religion. Okay, everybody is free to practice their own religion, to profess their own religion. Okay, India is democratic in the sense that the people of India get a vote, and the government is periodically elected by the people of India, and India is a republic. Okay, now all citizens of India are guaranteed their certain fundamental rights. The state has certain duties toward all the citizens of India and even toward all non-citizens, that is, all persons within the territory of India. Okay, these are the fundamental duties of the state. Also, within the fundamental rights are basically contained, because the citizen has a fundamental right, or because a person within India has a fundamental right, it becomes the duty of the state to ensure that that fundamental right does not get breached. Okay. Now, the courts have the responsibility of overseeing the functioning of the state. Okay, so whatever laws the state makes or whatever actions the state takes, it is the duty of the court to oversee the functioning of the state and to make sure that everything is in line with the constitution. Okay, now let's look at a sample question from constitutional law. Okay, the given legal rule is: discrimination shall be justified when such discrimination is absolutely necessary to promote the well-being of disadvantaged groups such as women, Dalits, religious minorities, sexual minorities, or disabled persons. Okay. Now the facts of this given example are: on 2nd October 2010, the governor of Bihar ordered the release of all women prisoners who were serving sentences of less than 1 year imprisonment to mark the occasion of Mahatma Gandhi's birthday. The question: is the governor's order justified under the rule? And these are your three options. Okay. So let's again take a look at the rule. The rule says discrimination shall be justified when such discrimination is absolutely necessary to promote the well-being of disadvantaged groups such as women. Now, in this particular case, the governor is ordering the release of all women prisoners serving sentences of less than 1 year imprisonment. Thus, we find that this particular action of the government falls within this rule, because this is a discrimination. This is a special provision being passed in favor of women. But the rule that we've been given allows for such special discrimination in favor of women, okay, because they are seen as a disadvantaged group. So the answer will be A, yes, because it is for the well-being of the women prisoners. Okay. Now, if in case the prisoners were under the age of 25 and above the age of 65 are also ordered to be released, will the order be justified then? Under this rule, that order will not be justified, because this rule very specifically mentions the disadvantaged groups which are for which the state is allowed to discriminate in favor of. Okay. So a group of people who are below the age of 25 and above the age of 65 are not either women or Dalits or religious minorities or sexual minorities or disabled persons. So in case prisoners under the age of 25 and above the age of 65 are also ordered release, that or the order will not be justified under this rule. Okay, so again, keep in mind, you have to apply the rule as is. Don't go beyond the rule. Okay, whatever question you've been given, whatever rule you've been given, just apply that rule blindly. Okay. Now, law of contracts is another area of the law where you will find a lot of questions coming in the CLAT exam. Okay. What is a contract? So let's briefly discuss what the law of contracts is. What is a contract? A contract is a binding agreement that can be enforced by law. Okay, it is a binding agreement between private individuals. Okay, it's either between two persons or between one person and a company. Okay, it basically when you as an individual undertake certain obligations, certain duties with regard to someone else voluntarily, okay, then that is called a contract. And the other person must also, in return, undertake certain obligations, either to do something or to pay you something, okay? And this entire transaction must be voluntary, okay? So the ingredients of a contract are: one, a contract must be entered into by free consent, okay? That is, no one must be coerced into entering into the contract, okay? Also, there must be no not only should you not be coerced, also there must be no fraud involved, okay? There should be no cheating involved which caused you to enter into the contract, okay? Nobody has lied to get you into the contract, okay? The contract must be by parties competent to contract, okay? The statute, the Contract Act, defines which parties are competent to contract, okay, and which parties are not competent to contract. So again, a valid contract, for a contract to be valid, the parties have to be competent to enter the contract, okay? A contract must be for a lawful object, it must be for a lawful consideration, and it should not be expressly declared void in the law, okay? Now we will go into each of these later on, but for now let us consider this question from CLAT 2011, okay? The given rules are: the fundamental right to freedom of association includes the right to form an association as well as not to form an association, okay? And the second rule is: the fundamental right to freedom of association also includes the freedom to decide with whom to associate, okay? These are the given rules. Now the given facts in this particular question are: Company A offered an employment contract of 2 years to X. One of the clauses in the employment contract provided that X must join PQR Mazdoor Sangh, one of the trade unions active in Company A. Now the question is, can X claim that this contract infringes upon X's fundamental freedom to decide with whom to associate or with whom not to associate, okay? So basically this is a contract. Now again, let's go through the essentials of a contract. A contract must be, like, keep this in mind, keep these points in mind now. A contract must be for a lawful object, okay? So anything that is declared in law to be not lawful and a contract is entered into there, that contract is a void contract or an invalid contract, okay? So in this case, X has the fundamental right to association, that is to choose whether to enter an association or not to enter an association and to decide whom to associate with, okay? Now in this case, Company A offers the employment contract to X but makes it a condition that he must join PQR Mazdoor Sangh. So can it be said that the company is forcing X to join this particular Mazdoor Sangh? Now in this case, the answer will be B, okay? Because if you look at the option B, it says the employment contract infringes on X's fundamental freedom to decide with whom to associate and therefore is not legally enforceable, okay? So according to the given rules, okay, because the contract forces X to be part of the PQR Mazdoor Sangh, it falls foul of the right to freedom of X to enter into an association or not to enter into an association, okay? So in this case, the answer is B. The employment contract infringes on X's fundamental freedom to decide with whom to associate and therefore is not legally enforceable, okay? Now let us look at the law of torts very briefly. We're just quickly running down the different branches of law that are commonly picked for asking questions in the CLAT exam, okay? The law of torts is basically a branch of law. Okay, now most laws are statutory in nature. That is to say, the laws are derived from a particular statute, that is a particular act of parliament. Okay, so for a contract, there's a Contracts Act. For a crime, there's the IPC, the Indian Penal Code. The law of torts, however, does not derive from any statute. It is a branch of law which developed in England and it has its own unique historical place. Okay, now what used to happen is, in addition to courts, there were courts of law in England. In medieval times, one could approach the king additionally for redress of perceived wrongs. That is to say, if someone suspected that they are being wronged against, then they could, if a remedy was not available by the courts, they could approach the king. Okay? And even if also if a law did not exist declaring an act illegal, but a party still felt aggrieved, they could approach the king. Okay. Now the king basically through the courts of equity, which is through the chancellor and through the chancery. The chancellor is basically like a minister of the king. Okay. So these were called the courts of equity. Okay. As opposed to the courts of law. Okay, as opposed to what are called the common law courts, okay, which is where the normal courts as we understand them. Okay, so these cases were that were brought before the king upon special request were basically administered by the courts of equity. Okay, these cases were decided on the basis of certain principles which have now become the law of torts. So that's where the law of torts has come from. And in today's day and time, we no longer have kings, or even in England, even in the UK, the king or queen doesn't have any special powers. So the law of torts is now applied by regular courts, but they are applied on the basis of these certain principles that were developed over time in the courts of England, in the courts of equity in England. Okay. Now, for an action to constitute a tort, there are two main requirements. One is that there must be an act or omission on the part of the alleged wrongdoer. That is, there has to be something that they have done or something they were required to do that they have not done for it to constitute a tort. Okay. Secondly, the act or omission should result in what is called legal damage. Now, legal damage, see, we understand the term damage normally as some harm that has been caused to you. Okay, but for legal damage to be caused, it's not necessary that some harm, like say for instance, either bodily harm or harm to your property or loss of value of something, such harm is not necessary. What is necessary is that a right of the plaintiff, that is the person who's approaching the court, his right should have been violated as a result of the act or omission of the wrongdoer. Okay, this is what is called legal damage, and it may not necessarily result in financial or personal damage. Okay, now let's look at this CLAT 2015 question. Okay, the given principle is a master is liable for all the acts committed by his servant in the course of his employment. Facts are, S is a driver working for ABC company. One day the manager asked him to drop a customer at the airport and get back at the earliest. On his way back, he happened to see his fiancée R waiting for a bus to go home. He offered to drop her at home, which happened to be close to his office. She got into the car, and soon thereafter the car somersaulted due to negligence of S. R was thrown out of the car and suffered multiple injuries. She seeks compensation from the ABC company. Now, so will ABC company be liable according to this given principle, that a master is liable for all the acts committed by his servant in the course of employment? Now, in this particular instance, S is definitely working for the ABC company. Okay, S was but the question we have to address, so he's basically a servant of the ABC company. Now the question we have to address is whether his giving a ride to his fiancée R is an action that is done during the course of employment. Okay. Now, the instructions that were given to S by the manager were basically to drop him off at the airport and get back at the earliest. There was no instruction saying that he should give a ride to R. Okay, as a result, S's actions are not during the course of employment in giving a ride to R. Hence, the answer in this case is B, that the ABC company will not be liable. S was not in the course of employment when he took R inside the car. Okay. Now let us discuss the law of crimes or criminal law. This is again one of the four major areas. This is the last of the four major areas from which questions are commonly asked in the CLAT exam. Okay. Now, criminal law deals with those actions which are classified or defined as offenses or crimes. The Indian Penal Code or the IPC defines offense as any act that has been made punishable by the code. Okay, so basically, what makes an act a criminal act? Okay, anything that has been defined to be a criminal act is a criminal act. Okay, the Criminal Procedure Code or the CRPC governs the process by which crimes can be dealt with. Okay, so the procedure by which the courts or the police will deal with a particular offense under the IPC is defined in the CRPC. Okay, and the third major act that deals with crimes is the Evidence Act, which provides for the standards which have to be followed while procuring and admitting evidence. Okay. Now, the big difference between civil and criminal matters is a difference in standard of proof. Okay, now what is standard of proof? Standard of proof is the level beyond which you must prove that a person has done something. Okay, now in civil matters, the matters need to be proved on the preponderance of probabilities. Okay, that is to say, I must prove if I'm alleging you have stolen something from me. Okay, and as a result, I've filed a civil suit against you to recover whatever it is. Okay, or for me to get damages for whatever you've stolen. Okay, in that case, I need to prove that it is probable. It is more probable that you have stolen it than it is probable that you have not stolen it. Okay, so in civil matters, this standard of proof is called the preponderance of probabilities. Whereas in criminal matters, cases need to be proved beyond reasonable doubt. That is to say, the job of the prosecution is basically to show that beyond any reasonable doubt that can be introduced, this person has committed this crime. Whereas the defense's job is to introduce reasonable doubt into the mind of the judge. Okay? Now, the definition of crimes not only includes acts which are made punishable, but also specify the state of mind of the person committing the act. Okay, that is to say, there are two parts to a crime. Okay, one is the act itself, and the other is the mental element. Okay, for instance, if we are traveling together in a bus, okay, and you happen to leave your phone behind, and I, without intending to steal your phone, pick up your phone, okay, then that is not theft. Okay, whereas if I take the phone while in my mind, my state of mind is that I wish to steal your phone, then that will comprise theft. Okay, so there are two parts to the law of crimes. We'll come to all of this in much greater detail later on. For now, let's look at this question from CLAT 2013. The legal principle is whoever desires any court to give judgment about any legal right or liability which depends on the existence of those facts which he asserts must prove that those facts exist. Okay, it's a bit complicated. Let's go through it once more. Whoever desires any court to give judgment about any legal right or liability which depends on the existence of those facts which he asserts. Okay, so if somebody wants a judgment in his favor, okay, and asserts that there are certain facts, then it's up to him to prove that those facts actually happened. Okay. Now the facts of this case: A asserts that B, C, and D have committed an offense of criminal conspiracy, and therefore A desires the court to give a judgment that B, C, and D shall be punished for that crime which A says B, C, and D have committed. Now in this case, nowhere are we told that A has actually shown before the court that B, C, and D were part of a criminal conspiracy. He only asserts that B, C, and D were part of a criminal conspiracy. Okay? So in this case, the answer is A. Okay? Because if I am alleging, again, let's go back to the principle. A, let's read this principle in light of the facts of the case. Okay, whoever desires any court to give judgment about any legal right or liability which depends on the existence of those facts which he asserts. Okay, A is asserting that B, C, and D were involved in a criminal conspiracy. So he wants a judgment on the basis of that assertion that B, C, and D were involved in a criminal conspiracy. Okay, thus, it is his duty to prove that those facts, that the fact that B, C, and D were in a criminal conspiracy exist, okay, for him to get the judgment in his favor. Thus, the answer in this particular case will be A. A must prove that B, C, and D have committed the crime. Okay. Now, let's discuss some more questions which are from previous year's CLAT papers. Okay. Now, in this question, the principles are: a master is liable for the wrongful acts of his servants. Okay. Second principle: a person can be called a servant only if there is a relation of employment and he acts under the order and on behalf of his master. Okay. Facts: X bank launched a savings scheme for poor sections of the society and the customer can deposit rupees 10 per day. Y, an unemployed youth, collected money from several customers and on behalf of them deposited the money. The bank gave to Y a small commission. After some time, Y disappeared without depositing the money as given by the customers. Okay, the customers bring a suit. Okay, so in this case, first and foremost, a master will be liable for the wrongful acts of his servant. Okay, but a person can be called a servant only if there's a relation of employment and if he acts under the order and on behalf of his master. So in this case, Y started on his own collecting money from customers on behalf of X bank. Okay, but after a while, the bank started giving Y a commission. Okay, for collecting money from the people. Okay, so in this case, through their actions, what X bank has shown is that Y was acting on their behalf, and because they had given a commission to Y, he was basically in the position of a servant. So in this case, the answer is A. The bank is liable because it paid commission to Y. Okay, now let's turn to this other question. This is from CLAT 2012. Ramu applied for the post of director in an organization. The governing body of the organization passed a resolution appointing him to the post. Okay. After the meeting, one of the members of the governing body informed him privately of the resolution. Subsequently, the resolution was rescinded. Ramu claims damages. So can in this case, the legal principle is not expressly given separately, okay, but it is sort of implied within the body of the question itself. Okay. Now the facts, let's go over the facts again. Ramu applied for the post of director in an organization. The governing body passed a resolution appointing him to that post, but it did not inform anybody of that decision yet. Okay, after the meeting, one of the members privately informed him of the resolution. Subsequently, the resolution was rescinded and Ramu claims damages. So in this particular case, what happens is the governing body made a certain decision and then it took back that certain decision. Okay, all without informing anyone on the outside. Okay, so what happens within that body remains within that body. So the answer in this case is B. Ramu cannot claim damages as there was no formal communication. Okay. Now this is another question from CLAT 2013. Principle: damages are money recompense as far as money can do for the violation of a right. Okay. Facts: an Indian citizen having the right to vote was not allowed to cast his vote on the polling booth by the returning officer. The name of A was mentioned in the voters list. A has also reported at the polling booth in time. However, the candidate in whose favor A would have cast his vote won the election anyways. So will A be entitled to damages? Is the basic question. Now looking at the principle again of this particular question, Damages are money recompense as far as money can do for the violation of a right. Okay, so in this case, we can say that the returning officer certainly violated the right of A to vote. Okay, so in this case, he will be liable for damages. So the answer in this case is C. Okay, because A will be entitled only to nominal damages. That is to say, while a right of his has been violated, okay, no real damage occurred to him, okay, and money can only go so far in giving him his right to vote back, okay. So the damages that will be awarded to him will be nominal, okay, will be in the nature of acknowledging that a right of his has been violated, but not a compensatory damage, okay. Now the next question from CLAT 2014. Principle: the transferor of goods cannot pass a better title than what he himself possesses. Okay, this is a legal maxim. Okay. Now the facts of this case are: X sells a stolen bike to Y, which Y buys in good faith. Now applying the principle to this given set of facts, the transferor of goods cannot pass a better title than what he himself possesses. Now because X has passed on a stolen bike to Y, okay, X does not have the title to the bike. Okay, as a result, he cannot pass on the title to Y. Okay, thus in this case, Y will get no title. The answer is B. Y will get no title as the transferor's title was defective. Let's look at another question. The given legal principles are: freedom consists in making choices out of two or more alternatives. Everyone has the freedom to speak. Okay, facts are: X says his freedom of speech includes the freedom not to speak. Okay. Now the answer to this question will be X's assertion is right, obviously, because clearly the freedom to speak also includes the freedom not to speak. Okay, so the freedom consists in making choices out of two or more alternatives. So in this case, his alternative that he is choosing is to not speak. So that is also a valid alternative. Okay, so X's assertion is right. The answer is B. Now let's look at this other question. This is from CLAT 2015. Principle: doctrine of double jeopardy. Okay, this is one of the doctrines in criminal law. Okay, no one shall be prosecuted and punished for the same offense twice. Okay. Facts: Maqbool bought some gold into India without making any declaration to the customs department at the airport. The customs authorities confiscated the gold under the Sea Customs Act. Maqbool was later charged for having committed an offense under the Foreign Exchange Regulation Act. Okay, so in this case, will the doctrine of double jeopardy apply to Maqbool? Now in this case, the customs department, what did they do? Did they punish him? They only confiscated the gold that he had brought into India. They did not punish him. They did not pass a sentence on him. Okay? They only confiscated the gold that he had brought in. And later on, he was charged under another offense, under a different act. Okay? So in this case, we can say that the doctrine of double jeopardy will not apply because he was not prosecuted twice. Okay? Thus, in this case, the answer will be B. He can be prosecuted because the confiscation of goods by customs authorities does not amount to prosecution by the courts. Okay? Okay, so that was a quick look at the kind of questions you can expect from the CLAT legal reasoning section. Okay, we've briefly covered the four major aspects of law that are commonly used to ask questions. Okay? We'll go into more depth, into more detail as regards each of these different kinds of laws: constitutional law, the law of contracts, criminal law, and the law of torts. Okay, we'll go into much more detail in all of these in subsequent sessions. Okay, till then, keep practicing and work very hard, and best of luck. Bye.